Hello, everyone. I'm Richard Fink, a lawyer who specializes in workers' compensation law in Ontario. Today is our weekly podcast, legal side of workers' compensation with Richard and Paul. Paul?
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with a specialization in workers' compensation and human rights law. If you want to reach out to either one of us or be part of our podcast or contact us, you can contact us through the links below. This week's topic is our special guest speaker, Karen London. I hope I didn't butcher your name.
So let me just do a brief introduction for Ms. Lundy.
Sure.
She has been a lawyer for approximately 40 years in the province of Ontario, who specializes in workers' compensation law for injured workers, has a huge amount of experience, and today is going to address the issue of time limits in terms of workers not meeting their time limits to make appeals, etc. So, Karen, take it away.
Thank you for having me, Richard.
My pleasure.
Okay, a limitation period is a time in which you must make a claim. And there are serious consequences if you miss a time limit. And this includes losing your right to pursue or appeal the claim. Now, time limits apply at the board and they apply to both employers and workers. And these time limits vary according to the party, being whether it's an employer or a worker, and also the type of decision being appealed or objected to. Employers have time limits too. They are required to report any injuries to the WSIB, which I sometimes call the board. And they must report these injuries immediately after they occur. If the worker is absent from work, if the worker loses pay, if the worker requires modified work at regular pay for more than 7 calendar days from the date of the accident. And the employer does so by submitting a Form 7. It's supposed to be submitted within 3 days of the date of the accident. And the employers are supposed to give a copy to the worker. And if the employer doesn't comply with, this is a law, if they don't comply with it, they may be fined. Now, in my experience, and I find that the board, the WSIB, tends to be tougher on workers than employers because I've experienced many cases where employers have not reported work accidents. And I've also observed that the WSIB or the board does not consistently enforce this law against the employers. And I know I've discussed with my colleagues about how employers from time to time pressure workers not to report accidents, and they sometimes pay workers their full salary while the workers are off work. Now, from my experience, this is not a good arrangement for workers, as workers may miss out on substantial or WSIB benefits, which are rehabilitation and healthcare benefits.
What happens when the employer says to the worker, don't report, take a few days off, we'll pay you, keep going. They miss the 6 months and then say month number 8, their back completely gives out on them. How does the board treat them?
Badly, I think. They give them trouble, and it can be quite intimidating. At that point, they need to see counsel to help them fix up this mess.
Like,
So, with the argument that you made, which is the employer told me to do this, does that work with the board?
I have a case right now, and it didn't work.
And what
doesn't
does
the
the, yeah,
oh,
go
sorry,
ahead,
Richard.
Paul.
I
Go
was
ahead,
going to
Paul.
say, doesn't the policy say, and I'm just reading from the policy, and I know what you're talking about is reality, the real world.
Yeah,
And I was reading somewhere in the policy because I did have a case like that where if the, and I did find it very, how would I say, restrictive. It said if the board's, what do they call it, compliance department or whatever, finds the employer had done wrong, then and only then that the time period would be waived. I was like, what do you think of that?
I had problems with that. I actually, on one of my cases, I did attempt to report to the compliance, and I didn't get a response at all. And I had to go other routes to get a time extension for the worker, and sometimes I'm successful getting the time. And I was going to discuss that later. Um, I had to go under other grounds for the exception to meet the time limit. Not always successful.
Yeah, I know. I had one case where I was actually fortunately successful at the tribunal where the worker didn't file an appeal, and I'm guessing because it's been a while. It was like 7 years. And the reasoning was that the employer basically misled him as to his rights to appeal in that, and the tribunal found that was 308/24. I don't think it's reported on Canley, but in that case, the vice chair, Greg, I think, I find her very fair at the tribunal. I'm not being, that every time I've had her, she's been very fair with decisions, and she agreed to overturn it and send it back to the board, which the board denied everything anyway. So now we're going back to the tribunal.
Yeah, and
So,
like that though, Paul, I find these clients that come to see me, they don't have unlimited resources, and it's a huge delay and a huge expense, and that's where I get very upset or concerned. Justice delayed is justice denied, and then I have to, as I've discussed with Richard and his staff, I have to find other sources of money for the workers so that they can pay me to fix it up, and not just pay me, but pay their bills. So it gets into a bit of a mess, and that's why I'm said it's not in your best interest to enter these kind of arrangements with employers to the workers, and it's better if they come see the lawyers or representatives right away, because otherwise they're looking into a lot of expense and delay.
Yeah, I would definitely say to workers today, before the minute you get hurt, and I'm laughing. Don't call an ambulance. Don't call a doctor. Call a lawyer, paralegal first. That's pretty bad, you know, because it's like you want to make sure that all your rights are protected. I would sadly I would say that's true as if like in cases where you're working in a big workplace, a big huge factory or something, and then the employer has a doctor or something on site. It's like, well, do you want to see that doctor? Do I have a right to refuse treatment from that doctor? And can I go to the emergency room? Stuff like that. Yeah. Would you agree with that or no?
Oh, I totally agree with you.
Yeah.
I wouldn't say right before the ambulance. I say, okay, get your health looked after first. But I'd say certainly before the 6 months run, get in to see a lawyer, and I'd say even a couple of months before the 6 months run, because it takes time for us to draft things and file things.
And I noticed too in the law and studying the law, where I got very frustrated was there was no time limits for injured workers to bring claims or appeals up until 1998 with the change of the law, the Workplace Safety Insurance Act. And so, in other words, almost 100 years it was that way. And I think the reason why there was no time limits is because it was fulfilling that purpose that Meredith said, which is when a worker becomes injured, they and their family now, because they provide for their family usually, become a burden to their family, friends, but most importantly to taxpayers. Because like you were talking about, first priority when an injured worker comes to you is are you being provided for right now? Because this appeal is going to take a long time and you have to pay rent, food, that kind of stuff. And oftentimes, and this is what angers me, is that when you contact the minister of labor or whoever they'll say go on welfare. And it's like, wait a minute, welfare is taxpayer funded. Workers' compensation is like private insurance. It's not insurance, but it's like that because it's not funded by tax money, it's funded by premiums charged to employers. So in that case, if I got involved in a car accident, you wouldn't say, well, go on welfare. You know what I mean? Like in an emergency, yeah, it just seems to me that it's abusing the tax system, and that's one of the reasons that they had not ever put in time limits. And then they did, and it's like it's just it seems to be really hurting taxpayers in my view. What do you think of that?
Well, I think the time limit is short because for car accidents, you have a 2 year time limit, and six
Yeah.
months is pretty short. And you got to consider too that a lot of workers, English isn't their first language, and they don't know what a time limit is. So I don't like it. It's too short, and a lot of workers aren't the most sophisticated people, and that's putting a huge burden on them. The other thing is about taxpayers' money. This is what I do, and I was going to talk about it later, but I'll pivot to it now. There are other related benefits that they're entitled to that don't come out of the taxpayer's pocket. Some workplaces have private disability insurance, and some workers might have disability insurance. Most of them don't, but some employers, some of my clients get it through their employers, and they got to apply for the short and long-term disability benefits. It's usually not as much as the WSIB benefits, but it's something to tide them over. But time limits the game for that too, and especially for the short-term disability, it's pretty short. But that's another thing I have to tell them because they don't know to apply for it. That's one thing I'll tell them to do. The other one is the unemployment insurance, and they paid into that. And again, there's a time limit because you have to contribute. I think it's 420 to 700 hours in the last year to get it. But that's something that they should be getting that isn't really coming out of the taxpayer's pocket. They put in their hours. And the third thing that's absolutely not coming out of the taxpayers' money is the Canada Pension Plan disability benefits. And they paid into that. And again, there's time limits and there's consideration to applying to that too. And the disability, it's better than the retirement benefits. It's more money, but it's not nearly as much as what the WSIB will pay. But will pay the grocery bills while they're waiting. So I usually try to set my clients up in getting all those benefits first. And it although it's not burdening the taxpayers, I think it is letting the WSIB off the hook more than it should be let off the hook.
So Karen, take the example, the worker strains his back doing some heavy lifting. The employer says to him, why don't just go on disability? You're, 50 years old. It's probably just your back's going on you. And they don't apply within the 6 months. How does the board and the tribunal determine whether to allow the time limit to be reinstated?
Okay, well, there are ways you can extend the the time limits, and that is you got to make a written request to extend it, and you have to have a good reason, and there's board policies for extending it. And the one that I usually try is that the worker has a condition that a serious health problem or condition that prevents them from understanding what a time limit is. And I've tried that with not with 100% success. Sometimes they're denied, and then I do have to go and appeal and go through the tribunal. And like getting justice delays, justice denied.
That's a very interesting point because Canada is, and more recently over the last several decades, is literally filled with so many immigrants, and many have, and I'm not criticizing them in any way, I'm just pointing out a point is that not only do they struggle in understanding the language and comprehending it, but it's also understanding the cultural points and the legal points.
Yeah, I agree. I totally agree. And the other thing that's really unfortunate too, and I have this all the time, even with sophisticated people, like they have this kind of accident and they hurt their back and they think that it's going to get better. And then after the 6 months, it's gotten worse. And it's because of that original accident, and it just really deteriorated. And that's why I really don't like that 6 month limitation period. Like with the car accident, you can watch the recovery up to 2 years before you're cut off. So I mean, you got to change the law. I mean, it's the 6 month is too short. Uh,
What about a year? Like the Human Rights Tribunal, Landlord Tenant Board, all pretty much most of the boards that I'm aware of are usually a year. I mean, personally myself, I think it should be 2 years for them as well. I think administrative justice should in many ways parallel the civil system, court system, I mean.
yes, yeah, I agree. A lot of times, people just don't know how serious, and they try to push through. And I mean, that's the really tragic thing. Like I've had a worker, and he just tried to push through, and he had a really good work ethic, and I loved him for it. But as far as his case goes, it hurt him for being somebody that had a work ethic and was trying to push through the pain.
Would you say that the difference between the board and the tribunal is the board tries to follow the rule, which is you didn't report in 6 months. We're not allowing the claim, whereas the tribunal's rule is if you report it to people, to doctors, to coworkers, to management, that my back is hurting me because I was doing a lot of lifting 7 months ago. The tribunal generally allows a time limit because there was some reporting versus the board, which says there has to be standardized document reporting.
It's been my experience that the board will try to deny typical insurance practices. They try to deny and hope you go away. And a lot of workers do go away. They do give up. I have a case now where the worker just gave up just because the board said 6 months, you're too late. And they didn't appreciate that. What happened to them? Their condition was related to work. So yeah, you have to go to the tribunal.
And would you agree with me the tribunal is just looking for some reporting?
I agree that they're much more flexible than the board. Yes.
Why don't you talk for a minute about the shortest time limit in the province of Ontario, which is return to work plans. So it's 30 days for a return to work plan.
That's right.
And I think the only shorter time limit in the province is if your car hits a pothole and the tire explodes. I think you have 15 days to report it to the municipality.
The,
Other
the,
than that, I don't think there's any 30-day time limits
oh, the,
throughout the entire province.
the city, if it's on city property, you got to give notice and
Oh, municipal. Yeah. Yeah, I'm
Yeah.
familiar with that. You have to give notice.
Karen, we're losing you from the screen. Come back to the middle.
Yeah. Yeah, I think too, Richard, is when you do appeals, or didn't they change the time limit for judicial reviews in the higher courts?
Well, judicial review is 30 days, I think,
Yeah.
but
Yeah.
they can easily they're very flexible in extending it.
Exactly. Like they're not absolute. Like that's one thing I noticed in that decision I mentioned that the vice chair specifically quoted in the interest of justice, meaning fair, to be fair,
Right.
right? They weren't like you said, Richard, with the board is they weren't just like looking like a horse with blinders on saying, no, it doesn't meet the criteria. And they
I
literally use the words holistic.
I think I tell about 3 or 4 prospective clients per week. The board is going to send you to a return to work program. You have 30 days to appeal it. And when I tell them this, they're like completely dumbfounded. Then I explain to them the problem is, let's say the WSIB is going to turn you in to a computer programmer and give you 2 years of college. And you think, great, that's a wonderful idea, and you don't appeal. Then when you finish the program, no one will hire you. You're toast. Your benefits are cut off. So if you're going to fight it, you can't fight it at the 2 year mark. You have to fight it at the 30-day mark. So send in an appeal form, say, I'm going to do my best, but it may not work. I appeal.
Or an intent to
And the
object or
workers are
everything.
just dumbfounded by this advice.
Yeah.
yeah, I know. I usually put in the appeal and then I tell them to cooperate. I put in the notice and just to protect the time limit. In fact, as soon as I get a bad decision, I put in the notice of intent to object. just to protect the time limit. And a lot of times I don't have the file and I can't give the reasons. I don't have updated access, but I just put it in just to.
Yeah. Yeah, how is that? Just thinking about that right now, because I actually have a file where, and the time limits are met, but I requested a complete copy of the claim file, and it was September 3rd, I think I sent the request in. And usually the board, since they've gone electronics, been pretty good with access, but in this case, I'm still waiting, and I'm gonna have to send a follow-up, I guess.
So Karen, when you miss the 30-day time limit, how does the tribunal deal with that for return to work programs? What are their basis for allowing an extension?
Uh, I've never had that situation where I appeal to the tribunal on that. And usually like I said, my practice is just to get it in so it's not missed. Um,
My
I don't.
own experience has been that if the worker had no reason to appeal the program, i.e., they thought this will work, and then a year or two later they realize it's not going to work, either their health won't permit it, or there's no jobs at the end, or the program was insufficient to get them a job. There's case law from the court saying time limits can be extended when there's no knowledge that you're going to suffer negative consequences. So the tribunals extend time limits on the 30 days for return to work programs on the basis the worker had no knowledge that the program could possibly fail and did fail. So it's the time when they realize the failure is the time the 30 days starts to run.
And usually they make a change to the return to work program. They vary something. So usually at that time, if you notice the problem, like I know my worker started the program over a year ago, and then they made a change uh, to the either the occupation or the what they were going to allow. So I guess you'd have a further chance of a further kick at the can in that case.
Yes, so if they change, they say you're going to school for 6 months instead of four, they issue a new letter and the
Yeah.
time limit runs again.
Oh yeah, you can try to object again. Yeah.
So how successful in general do you think you are in extending these time limits, both the return to work and report the accident?
Report the accident. I think I've been mostly successful, although there's some times where I have been really surprised and disappointed where somebody has a major psychiatric illness and they absolutely they couldn't understand, or their health was so bad that they just couldn't deal with it. And I've had to fight a lot on those ones, and I haven't always won. And then a lot of times it's the workers giving up because they'll just say, "Oh no, I missed the time limit," and they just said, and I won't get instructions to proceed for them. But I've had more success on that than the return to work. Although, like I said, it's my practice just to say I do a notice of intent to object, saying I got this decision. I just want to protect the time limit, and I'll provide further reasons at a future point of time. So I just that's my practice. So I haven't really when I've had the cases, I haven't run into that problem. If somebody already missed it, I haven't had to fix that up. And if I did, I would have done it by finding a later decision and trying to push that through the board. I think a few times I was able to push it through, but it's arbitrary at the board, I find. And it's
It's
probably,
not consistent.
yeah, very arbitrary. Depends who you get.
So Paul, would you like to add anything?
Um, no, I just agree with Karen that And you have said many times, Richard, how many times have you said that the problem with the WSIB is they're not helping injured workers manage their work injury? And I would go so far as to say, is this bureaucratic appeal process and decision-making system just only adds to the injury. I recall recently some research studies where they're starting to actually study the impact of the system on injured workers mentally as well as physically. Like one of the concerns I have is the healthcare treatment. They're very limiting to it, and you have to appeal it, and you got to meet that time limit. But remember, you're dealing with the actual injury and your inability to be, as we say, a normal person. That on its own is a problem. And putting these time limits in, it just, you know what I mean? It just isn't right.
That's a very good point on the treatment issue. Plus, where does the worker get the medical understanding that he needs a psychologist and an occupational therapist and not just a physiotherapist?
And
Where does his
yeah,
understanding of that come from?
the other point I wanted to make about Karen, when you were talking about when your injured worker first comes to you and says, "Okay, we got to figure out how for you to survive because you've lost your ability to earn a living and you haven't got any income." What would you say if I told you in Alberta, when it was the NDP, they changed the law and incorporated what's called as interim benefits? So when a worker is appealing a decision, in some cases and situations, and of course there's criteria and everything else, that some injured workers get interim benefits while they're waiting. In Ontario, the law says that, but that's only if the board says, yes, Richard, you're entitled to benefits, and Karen, who's the employer, appeals it. Then the worker keeps their benefits, right? Whereas in Alberta, even in initial entitlement cases, they can apply for what's called as interim benefits. But since it's gone away from NDP government to a conservative, the law still remains, which I was surprised at, but the decision process, like you were mentioning earlier, is very aggressive, I'd say.
All right. Well, I'd like to thank everyone for participating and watching our podcast. And we hope to see you in another week or two. Thank you very much. Good day.
Good day, everybody.
Yep, thanks.